Welcome, everyone. Today we're doing a deep dive into a really interesting Supreme Court case, United States Agency for International Development v. Alliance for Open Society International.
That's right. And just to set the stage, the court actually reversed the lower court's decision here.
Okay, so what was the core question they were looking at?
Well, it boils down to this.
Yeah.
There was a funding rule, right? A condition requiring groups getting USAID money to have a policy against prostitution and sex trafficking.
A policy we already know the court said was unconstitutional when applied to the U.S. organizations themselves?
Exactly. That was decided earlier. So the question this time was, could the government apply that same rule to the foreign affiliates of those same U.S. organizations? These affiliates operate overseas and are legally separate.
Got it. So separate legal entities, but affiliated. And Justice Kagan sat this one out, right?
Correct. She was recused. So the whole dispute really centered on these legally distinct foreign groups linked to the American ones.
Okay, let's get into the arguments then. Maybe start with the petitioner, the U.S. Agency for International Development. What was their main line of reasoning?
Their core argument was pretty straightforward, legally speaking. They said, look, foreign entities operating outside the U.S., they don't have U.S. constitutional rights, period.
So First Amendment rights don't extend to them abroad.
Right, and therefore a funding condition that might violate the First Amendment if applied to a U.S. group, well, it's perfectly fine to apply it to these foreign affiliates.
And the fact that they were legally separate entities, that was crucial for the government.
Absolutely crucial. They really hammered that point home. Formal legal separation means they are distinct, so different rules can apply.
Did they address the fact that these groups often seem like one entity to the public? Shared names, logos?
They did acknowledge the shared branding, the public face, but they kept coming back to the legal structure.
The formal separation trumps the shared identity, in their view.
Pretty much. They also pointed out that these foreign affiliates had apparently been following this policy for, 17 years?
Wow, 17 years.
Yeah, and the government argued there wasn't really any evidence that this harmed the overall AIDS relief programs or, significantly interfered with the U.S. group's own messages.
Okay. What about the argument that sometimes you have to use a foreign entity to operate effectively overseas? Did the government push back on that?
They did. They said, first off, it's not always necessary. Some U.S. groups use branch offices. And second, after the first Supreme Court ruling.
The one protecting the U.S. group.
Right. After that, the U.S. groups had a clear choice. Operate domestically without the condition or choose to work through a foreign affiliate that does accept the condition. It's their choice how to structure things.
So the government saw it as a voluntary decision by the U.S. groups to affiliate with foreign entities under these rules.
Exactly. They also pushed back on the idea that the government's own affiliation guidelines help the other side. They argued the guidelines actually allow for affiliation even with policy differences, especially if there's legal separation.
And just to remind ourselves, the U.S. organizations, the respondents here, they aren't subject to this policy directly anymore because of that earlier case.
Correct. That's key. The government stressed that this current fight wasn't about taking funds directly from the U.S. respondents based on this policy.
Okay. What about those exemptions in the law, like for the Global Fund or the WHO? How did the government explain why they didn't have to follow the rule?
Their explanation was that those organizations are different beasts entirely. They're made up of sovereign countries, essentially.
Yeah, international bodies composed of governments.
Right. So Congress likely treated them differently out of respect for the sovereignty of their member nations, which wouldn't apply to these nonprofit organizations.
Did they clarify if taking the pledge stopped groups from actually working with prostitutes for, say, AIDS prevention?
Yeah, they made a point of saying it didn't. The pledge was just about having a stated policy opposing prostitution and trafficking. It didn't prevent, and they even said the government encouraged, actual outreach and prevention work within those communities.
So the government really framed this as the respondents trying to stretch that earlier court win way too far.
Definitely. They saw it as an attempt to get global relief for their foreign affiliates, extending a ruling meant for domestic entities.
And they warned about wider implications.
They raised concerns that a ruling against them could maybe, down the line, call into question other rules about foreign speech, like bans on foreign money in U.S. elections, sort of a slippery slope argument.
And finally, they just pointed to the program's success.
Yeah, they highlighted that the AIDS relief program has been very successful overall, working with both domestic and foreign groups under these conditions for years. Their bottom line was, This condition is fine for foreign entities.
Okay, makes sense from their perspective. Now let's switch gears. What about the respondents, the Alliance for Open Society and the others? What was their main argument against applying the policy to their foreign affiliates?
Their whole case revolved around this idea of attribution. They argued that even if the policy only applies to the foreign affiliate,
Which is legally separate.
right, even so, it effectively forces the U.S. organization to speak because the public sees them as one and the same. Shared name, shared logo, shared mission, it all gets attributed back.
So the public perception blurs the legal lines.
That's the core of it. They argue they speak with a single global voice, and the foreign affiliate taking this pledge makes it seem like the U.S. group endorses that message too.
And they felt this forced them into a corner.
Yes, either they stay silent and appear to endorse a policy they disagree with, or they issue some kind of public disclaimer.
Which they argued wouldn't work.
Exactly. They felt a disclaimer would just look like hypocrisy or doublespeak, given how tightly linked the organizations appear. They said it damages their credibility, especially on sensitive public health issues.
So the harm they claimed was this compelled speech through attribution, damaging their reputation and effectiveness.
Precisely. They even proposed a kind of test. If organizations are part of a global network sharing these key identifiers, then this risk of attribution is real.
What about the government's point that the U.S. group could just issue a disclaimer? You said they felt it wouldn't be effective.
Yeah, they really pushed back on that. They argued the entities are basically indistinguishable to the public and operate as one voice, so a disclaimer just wouldn't cut it. It would undermine their whole message, they claim.
And they did concede that the foreign affiliates don't have First Amendment rights on their own.
They did concede that point, yes. But their argument was about the effect on the U.S. organization's rights. How far can the government go in imposing conditions indirectly through these affiliates?
Especially, I suppose, if the U.S. group gives money to the foreign affiliate, like a subgrant.
Right. They pointed out that in those cases, the U.S. group is still sort of tied up in enforcing and policing this policy for its affiliate.
How did they respond to the government's argument about having broad power over how it spends its money?
They tried to frame this specific requirement as different, as a kind of unique ideological litmus test that goes too far, even under the spending power.
So they argued the harm wasn't just theoretical, but it actually impacted their reputation in the health community.
Yes, they asserted real harm to their brand, their integrity. They stressed that on issues like HIV/AIDS and prostitution, people take stances very seriously, and this forced pledge situation undermines their trustworthiness.
It sounds like they really believed the public just doesn't make that distinction between the U.S. parent and the foreign child organization.
That was their consistent view. They even drew an analogy, comparing it to compelled speech cases like Masterpiece Cake Shop. Forcing the affiliate to speak was like forcing the U.S. group to speak.
Interesting analogy. What about the hypothetical Justice Kavanaugh raised about funding NGOs based on recognizing Israel? How did they handle that?
They seem to suggest that maybe such a condition could be okay if it aligned with the U.S. entity's own message or core purpose. The key difference for them was whether the government was conditioning its own message versus compelling an ideological stance from the organization receiving funds, especially when that stance gets attributed back.
And they dismissed the government's concern about foreign election influence?
Yeah, they basically said that's a red herring. Their argument was about compelled speech and attribution in this specific funding context, not about campaign finance law.
So boiling it down, their argument was, making our foreign affiliates say this puts words in our mouths and we can't effectively take them back without hurting ourselves.
That's a good summary of their position, yeah.
Okay, so then the government got a chance for a rebuttal. What did they emphasize at the end?
They really doubled down on the points we heard earlier. First, the concession. Respondents admit unaffiliated foreign groups have no constitutional rights here.
Right.
Second, control. The U.S. entity chooses to affiliate. It's their decision to link up with a foreign group that accepts these funds and conditions.
So they distinguish this from cases where someone is truly forced to associate or speak.
Exactly. They differentiated it from cases like Hurley or Masterpiece. Here, there's a choice in how you structure things and accept the money. They also stress that U.S. First Amendment rights can't be altered just because of foreign laws or how you choose to operate abroad.
And they weren't buying the risk of attribution test.
Not at all. They called it unworkable, potentially dangerous for other foreign speech regulations, and said it confused speech attribution with actual speech compulsion.
Their point being, the foreign group only has to say it if the U.S. group chooses to affiliate and take the money under those terms.
Precisely. And they argued the respondents' claim about interference with their message just didn't hold water.
Did they comment on the timing of this attribution argument?
Yes. They pointed out it hadn't really come up for, like, the first decade of this whole legal battle. They sort of painted it as a late-game attempt to expand the win they already got for the U.S. entities. So they wrapped up by saying there's just no legal foundation for the respondents' position, and siding with them would kill a longstanding, effective congressional provision.
All right. That covers the arguments well.
Yeah.
Now let's shift to our 10th chair perspective. If you had that hypothetical 10th vote, how would you be thinking about this?
Stepping into that seat, this case really does feel like a tough balancing act. You've got the government's understandable interest in setting conditions for its foreign aid, and legally, the separation between the U.S. and foreign entities is, well, it's technically there. But the practical reality, especially with global branding and how these groups present themselves, it really does blur those legal lines, doesn't it? The idea that the foreign affiliate's required statement could genuinely be seen by the public, by donors, by partners, as the stance of the U.S. organization that feels like a real possibility.
So the risk of attribution seems plausible.
It seems plausible, yeah. And that raises a genuine First Amendment question, even if it's indirect. Are you essentially burdening the U.S. group's speech by conditioning funds for its closely linked foreign counterpart? It's not straightforward. You're weighing the government's foreign policy goals against potential, even if indirect, infringement on domestic speech rights. The formal legal structure might not capture the whole picture in today's interconnected world of global nonprofits. It's tricky.
A very nuanced take. So wrapping up our deep dive today, as we heard, the Supreme Court ultimately sided with the government, reversing the lower court.
Right, meaning that funding condition can be applied to those legally separate foreign affiliates.
And this decision definitely has significant implications for how U.S. foreign aid works and for any U.S. organization operating internationally through affiliates.
Absolutely. It leaves us with a big question, really. In this globalized era, how does the U.S. government effectively pursue its policy aims through foreign aid while respecting the First Amendment rights of the U.S. groups it partners with, especially when those groups and their foreign affiliates are so closely intertwined in the public eye? Finding that balance is clearly an ongoing challenge.
A critical question indeed. Thanks for joining us for this deep dive. We hope you'll join us again next time.